Okay, so I suppose everyone who wanted to join us today already here, so I suppose we can start. So good afternoon, everyone. We welcome you for today's webinar about the MiCA requirements and general MiCA compliance for the crypto industry in the European Union from now, actually. And we are thrilled to have you join us as we explore these requirements today. So before we dive into our discussion, I would like to introduce our speakers for today. So the first one will be Alexey Los, legal professional at Icon Partners and Faithful Web3 guru. He will be sharing insights on classification of crypto assets and global MiCA applicability. And the next one we have Vladislav Fudiansky, also legal professional at Icon Partners, and he'll bring a wealth of knowledge in regulatory compliance. So he will be focusing on distinction between different players according to MiCA. Also, please note that we will have a QA session after the main part of the webinar, so feel free to send your questions in the chat during the webinar, and we will be happy to answer all relevant questions after the webinar. So I suppose now we can start, and let's move on. So Alexey, please.
Yeah, hi everyone, nice to meet you. Thank you, Andrei. As Andrei said, today we will observe some issues regarding the new MiCA regulation within the European Union, its applicability, scope of regulation, and some requirements to those who wants to deal on the crypto market in the European Union. So first of all, let's start with the main question: what is MiCA? What is the scope? Why, in generally, we need to know about this regulation? First of all, MiCA establishes a single unified legal framework for crypto asset regulation across European Union member states and aiming to replace the diverse national laws with cohesive policy. So that means that MiCA regulation, by its nature, is regulation which is applicable directly within each member state of European Union, and it will, let's say, substitute the single regulations which are now in force in those member states. As for significance of these regulations, it is necessary to say that MiCA represent a significant step towards standardizing crypto regulations in the European Union, promoting healthy competition, enhancing transparency, and providing clarity and certainty for market participants, though it introduces additional obligations for actors and participants on the crypto market in the European Union. So also, the main aim of this regulation is to support innovation and fair competition while ensuring a high level of protection for retail holders of crypto assets and, of course, the integrity of crypto asset markets within the European Union. That's why MiCA establishes a uniform requirements for the public offer and admission to trading on a trading platform of crypto assets other than asset reference tokens, also asset reference token itself, and e-money tokens. So the next one, I suppose we need to pay attention to the applicability of MiCA and also the time frame and timeline for MiCA implementation. In general, MiCA were signed in 2023 with partial implementation earlier in June 2024, which means this year, approximately 2 months ago. So, the full entry into force will be on 30th December 2024. By the way, if we are talking about the early implementation, there was implementation of two parts, significant parts, considering their scope of regulation, and it refers to the asset reference tokens and to the e-money tokens. Also, it is necessary to mention here about the implementation and the force of MiCA regulation. MiCA features an innovation authorization mechanism allowing a license obtained in one EU member state to be valid across all member states. So, which means that in case, for example, service provider obtain a license in the home member state, they can deal with this license within the whole European Union. So the next part, we need to pay attention to the scope of regulation, and let's say it will consist of two main questions. First of them, who does MiCA apply to? Here is necessary to mention that this regulation applies to natural and legal persons and certain other undertakings that are engaged in the issuance, offered to the public, and admission to trading of crypto assets, or that provide services related to the crypto assets in the European Union. So considering this definition, we can see the main actors, and there are crypto asset service providers, which means entities providing one or more crypto asset services, and we will discuss them a little bit earlier. Also, issuers, it's in general natural or legal persons or other undertakings who itself issuing crypto assets, and offerers sometimes, and I suppose in more cases it will include issuers, so those entities who offer crypto assets to the public. So also, while we're talking about these three main type of actors, and especially as for issuers and offerers, it is necessary to mention that considering the type of crypto assets which they may issue or offer, there are maybe different obligations and different rules which will be applicable to those actors. But also, as for MiCA, as we know, this regulation excludes certain like actors and certain type of relations. Now we are talking about notable exclusions from this regulation, and it refers to the following one. So MiCA will not apply to the persons who provide crypto asset services exclusively for their parent companies or for their own subsidiaries, for example, and etc. MiCA regulation also does not apply to the certain financial institutions, like, for example, European Central Bank and national central banks, and also to the public international organizations. But one of the most significant exclusions here are decentralized exchanges. So according to the text of MiCA regulation, there is stipulated that MiCA regulation shall apply to the relations where the certain intermediaries involved, for example, crypto asset service providers, which in fact provide the services, something like custody services, let's say, or exchange services. But in the situation where we have a fully decentralized relations, for example, those which govern through the smart contracts only and in fully decentralized manner, MiCA will not apply here. So the next point, consider the type of assets which will be regulated under the MiCA regulation. First of all, of course, we understand that MiCA will regulate the crypto assets, which defined according to MiCA as a digital representation of a value or of a right that is able to be transferred and stored electronically using distributed ledger technology or similar technology. And here it is necessary to pay attention to the three main types of crypto assets, which are, let's say, defined, classified according to the MiCA. The first one will be electronic money tokens. Such tokens defined similarly to electronic money under a certain directive, which is already applicable in the European Union. And so they may be used, and first of all, they are intended for payment purposes and provide holders with a claim against the issuer for redemption at par value of those tokens.
Can you please provide some examples, maybe for us?
Yeah, sure. So one of the most significant and notable examples here will be USDC, which is the stablecoin issued by Circle. I'm sure that a lot attendants here know about that and about this token. The rather interesting thing is that this token, it was already, let's say, licensed according to the MiCA regulation, because Circle, they have registered their entity in France, and they have submitted already all necessary documents like white paper and other documentation to the local authorities in France, and they obtain an electronic money institution license to be entitled to offer and to issue those e-money tokens. Also, we can mention here the newly represented token, which is URI. It was listed on Binance approximately a month ago, if I'm not mistaken. So there are also another euro related token, and they are also regulated under the MiCA regulation because they have registered their entity, if I'm not mistaken, in Luxembourg, and also submitted all the necessary documents. The rather interesting thing here that according to the second project, which is tokenized euro, in fact, and electronic money token. So the key, let's say, key element here, they state that they will submit and issue those euro tokens one-to-one for euro, of course, but only when the customers ask them. So, which means that only when customer refer to those tokens and want to obtain those tokens, they will accept money directly from their customers in exchange for their tokens. So in fact, they want to be backed by cash for each of their tokens to be issued. If we are talking about the USDC token, they may use another model and for another reserves. So another asset here will be asset reference tokens. These tokens aim to stabilize their value by referencing a variety of assets or rights, and including fiat currencies, to ensure regulatory coverage and future proofing against circumvention. So, which means that these tokens, they their main aim to be regulated and to refer to the value not only one official currency, but to the basket of value of all rights, which means that it can be like a combination of certain values or rights, and such assets, in fact, will be tokenized and will be represented on the blockchain. The third type of asset here is crypto assets other than asset reference tokens and e-money tokens. As for these type of assets, it encompasses a broad range of crypto assets beyond two previous types of tokens, and it may also include, for example, utility tokens. But it is necessary to be aware that according to the MiCA regulation, utility token, they are also defined separately. I mean that MiCA provides us with um, a definition of the utility token, which means a type of crypto asset that is only intended to provide access to a good or a service supplied by its issuer. So that's also like a significant definition and significant element of these type of crypto assets. Here we can also, by the way, discuss the situation with USDT token, because as far as I remember, even some months ago, there was a discussions related um, to the USDT classification and how the regulators will treat these tokens, how USDT will consider about these new regulations, what they will do, and etc. As far as I remember, there was even some news that some exchanges, they want to delist USDT for the customers within the European Union in case the USDT will not obtain the approval and will not submit necessary documents. Because in fact, USDT, in my opinion, also can be classified as electronic money tokens, considering that they referring their value only to the one official currency, which in fact also USD.
Yeah.
So, and here it is necessary to understand that such electronic money tokens, they can be backed by not only the cash and this official currency. The main point here that it shall refer to the only one official currency, but this token, in fact, can be backed by different class of assets. For example, if we pay attention to the USDC token, we can see there that they are backed by other assets, something like US Treasury bills and etc. The main requirement here that the value of such reserves, it shall be denominated to the official currency, and each time it shall be in proportion 1-to-1 to the issued amount of tokens. So,
but what about NFTs? Does MiCA say anything about it?
yeah, exactly. So this is another interesting point here regarding the regulation of NFTs under the MiCA, because in fact, MiCA doesn't apply to crypto assets that are unique and non-fungible with other crypto assets, of course. It is also provided in the text of MiCA that they will pay attention to the certain like features of such tokens to identify whether such assets they are really unique and non-fungible, or they can be changed and they can be substituted by any other similar asset or something like that, which in fact will provide the same rights or the same opportunities, the same access to, I don't know, maybe some services like utility tokens and etc. And that's why they state that assigning a unique identifier to a token, it will not be an indicator of non-fungibility of such token, because I'm pretty sure that a lot of issuers of NFTs, especially if we are talking about the collections in amounts of 10,000 NFTs, 8,000 NFTs, they may have in fact a really identical like picture, identical rights assigned to those assets, and the key difference between them will be only technical, which means that unique identifier will be assigned to a certain NFT, which will allow us to identify that this exactly only one, let's say, copy of such NFT on the blockchain. But if we are talking about this situation from the point of view of regulators, in fact, they will not consider it like the feature of non-fungibility, and they will state that no, guys, your tokens, in fact, are interchangeable. That's why they shall be regulated as standard crypto assets according to the MiCA regulation, and you shall comply with our requirements regarding the issuance and regarding the offering to the public of such crypto assets, because they follow the rule, which also stated in the text of this regulation, that competent authorities, they should adopt a substance over form approach, whereby the features of the crypto asset in question determine the classification and not its designation by the issuer, which means that you can state a lot of different information, and you can provide a lot of different arguments in your marketing communication that look, our tokens and our NFTs in fact unique and etc. But in case they will provide the same rights to their holders, let's say the NFT node sale of NFTs. So in case your NFT will entitle anyone who owns this NFT to launch the node and to maintain the network, in fact, they may consider and classify it as a regular crypto asset, which shall be regulated according to the MiCA. And of course, as I stated previously, NFTs issued in large series, it's also like one of the markers of the fungibility of such NFTs. Here is another interesting question regarding the scope of MiCA regulation, considering the RVA narrative, which means that real world assets, and considering the tokenization issues, because a lot of startups, they're interested in tokenizing different assets, real world assets. I mean, also considering some of them shares in the company or other rights which will entitle someone to receive profit, for example, something like that. It is necessary to be rather attentive here, because first of all, MiCA will not cover the assets which in fact represents financial instruments, deposits, pension scheme, etc. So which in fact represents those sphere of relations which are already regulated within the current frameworks in the European Union. Just a simple example is shares, because I'm pretty sure that everyone here already know about the approach taken in the United States by the Securities Exchange Commission, where they claim it as a securities and consider some tokens and let's say the scope of rights which are related with those tokens as the investment contracts. That's why, in fact, consider such tokens as the securities. According to the MiCA, such tokens they will not be regulated by the MiCA regulation and MiCA provisions, because in fact, in case your token is classified as a security, as a financial instrument, that means that it shall be regulated under the existing law, also under the MiFID II in this case. And to understand how the regulators will classify these tokens, it is necessary to pay attention to the guidelines that were issued by the ESMA, one of the regulatory body designated by MiCA. They stated that while classifying tokens, it is necessary to follow the following approaches. First of all, it is necessary to pay attention on a case-by-case assessment because it is necessary to consider specific features, design, and rights attached to the certain crypto asset. Another point here is technology neutrality, which means that technological structure of an asset is irrelevant for the purpose of its assessment. And in fact, if the certain rights attached to the crypto assets, they are characterize these crypto assets as a transferable security, for example. So such crypto asset will be considered as a transferable security and will be regulated under the relevant law. Also, of course, it's a substance over form again, because the classification of the digital asset should take into account its actual features, not just the label given by the issuer or offerer. And also a hierarchical approach, which means that if a digital asset displays more features of financial instrument, such features should take precedence in its classification. And in general, in the text of MiCA, it is stated that they follow the principle same activities, same risks, and that's why same rules. So in fact, in case we will have the tokens with the same features related to the other types of assets, they will be regulated within the existing frameworks. So here we can move forward to the next topic, which will cover the crypto asset services, which are regulated under MiCA regulation and the definition of the crypto asset service providers. Because in fact, crypto asset service provider means a legal person or other undertaking whose occupation or business is the provision of one or more crypto asset services to clients on a professional basis, and that is allowed to provide crypto asset services in according with the MiCA, which means that they were licensed according to the MiCA regulation. In fact, MiCA provides a rather vast list of of crypto asset services, and such services include providing custody and administration of crypto assets on behalf of clients, operation of trading platforms for crypto assets, exchange of crypto assets for funds, and exchange of crypto assets, for example, for other crypto assets, also transferring of crypto assets, and etc. The full scope of the services covered by MiCA you can see on the screen. In fact, what is necessary to know regarding these type of services and the main question about the requirements. MiCA stipulate the general requirements to all of the crypto asset service providers, and it states that they have certain common obligations. Generally, three main obligations, which is the duty to act honestly, fairly, and professionally in the best interest of customers, of course. Also, the duty to provide fair, clear, and not misleading marketing communications, and the duty to warn their clients of risks related to their crypto assets. Moreover, MiCA also provides certain specific requirements like minimum capital requirements, secure crypto assets and fund storing, functioning complaint management system, and adequate procedures to identify, prevent, manage, and disclose conflicts of interest. But in fact, everything depends on the certain type of services which you are intended to provide to your customers, and that's why the requirements for the certain type of services, they may be rather strict, and they will different from the other, for example, like providing advices and etc. But I'm sure that my colleague Vladislav will tell you a little bit more about this topic, considering that he know a lot of information regarding those specific requirements depending on the types of crypto asset service.
Thank you, Alexei. Thank you for your valuable insights. Okay, so we can move forward for now. And I want to mention one more time that if you have any question, please state it into the chat with this meeting, and we will answer them after our main session. So yeah, okay, Vlad, you can continue. Thank you.
Hello, everyone. Andrei, how do you hear me?
Well, actually, everything fine.
Okay, so Alexei, thank you very much for this interesting speech. It was very informative and concise, and looking forward actually to implementing all those advices. From now on, I will take a speech, and we will cover some additional questions regarding crypto asset types, regarding requirements for those, regarding crypto asset service providers, specific requirements on them. Also, we will touch on the question of transfer of funds regulations and amendments. And furthermore, we will speak a little bit about regulators and fines on the violators. So, as you know, we are standing at the crossroads between regulation and innovation. The governments are striving for balancing those two extremes, and you may treat differently the MiCA. It is not ideal, but as my colleague has said before, eventually MiCA has brought the much needed clarity. Furthermore, it has brought the legal certainty on the most important questions. So now we have three main categories of regulated crypto assets. It is that much needed clarity that we couldn't understand before. First of all, there were different regulations in different countries of European Union, but now everything will be harmonized. So those three crypto asset types are other crypto assets, the most diverse and largest category, asset reference tokens, and e-money tokens. Furthermore, MiCA does more than just categorizes crypto asset types. It provides the clarity regarding regulated activities with crypto assets, such are issuing crypto assets, offering them, seeking admission to trading with some type of crypto asset, and providing intermediary services like crypto asset services. So it is not just a mere technicality, as I said, it is actually a foundations upon which your obligations will be built. So you shall add the crypto assets you will be dealing with to the regulated activities, and you will get the sets of requirements which are imposed on you. Furthermore, we shall remember that issuers are not equal to offerers. These are two different subjects, and they actually have different requirements. We will see it further on the next slide. So on this slide, you may see the preliminary roadmap for those who want issue or offer the crypto assets. We will presume that persons seeking admission to trading have very similar obligations with offers, because it is really like so under MiCA. So the first step you shall do before issuing or working with crypto assets, you shall understand with which crypto asset you will be dealing. So these are three main categories, and let's reiterate it: other crypto assets, asset reference token, and e-money token. After that, after completing this third pillar, you shall move to the second step, understanding your activities, your main roles. So we will disregard for this step crypto asset service providers. We have the special slide for that, but you shall understand whether you are an issuer or offerer. I reiterate that persons seeking admission to trading, they have very similar obligations to offerers. So it is the second pillar on which your obligations will be built. Why is this important? Because we are moving to the third step, the elephant in the room. It is when you shall obtain licenses and authorizations. So if your first answer was you are an issuer, but you are not offerer, you don't offer or solicit anyhow in the public, then you don't have any requirements actually imposed on you. MiCA actually imposes those requirements on offerers of other crypto assets. So only if you are an offerer or if you are an issuer and you are soliciting a public with your offering of crypto assets, you will have some requirements. However, I focus your attention that other crypto assets, they don't include any requirements, obligations to obtain licenses and authorizations. There is a requirement to prepare and publish white paper. and publish the consistent with white paper marketing communications. Contrast this with asset reference token and e-money token. If you are an issuer, I repeat, an issuer, not an offerer. If you are an issuer of asset reference token or e-money token, you shall get licenses and or be authorized. For asset reference token, you shall be either licensed as credit institution or authorized as general legal entity, which is more applicable to us, actually, in most cases. So if you want to be authorized as the general legal entity, you shall submit your application to home member state. So you shall have a registered legal entity in some of member states of your European Union. The application is actually general. You shall submit some general information like information on your legal entity, on your shareholders, articles of association, and etc. But there are specific requirements. For example, you shall submit which crypto asset type you will be dealing with. Furthermore, which functionalities it will include, why it is asset reference token, and furthermore, you shall also keep at all time, I repeat, at all time, minimum capital of 350,000 euros to be authorized as a legal entity which can issue asset reference token. There are no such requirements for offerers, and actually issuers, if the offer is third party, for example, issuer shall include any information of such offer. So issuer shall ensure that the offer is in compliance with MiCA regulation. Why it is so, you may ask? Because only an issuer can ensure that some specific requirements are met. Because as you may see on the 6th step, there is a requirement for reserves, and only an issuer can keep those reserves. Furthermore, redeem tokens for actual money. Let's move to another question of e-money tokens. We are still on the third step. We are still on the third step. 1 second. E-money tokens, you also shall be an issuer, and also only an issuers have obligations. So you shall be licensed as a credit institution or e-money institution under e-money directive. Yes, Andrei?
Yeah, sorry for interrupting. I just want to ask if there is any exceptions for those rules.
Yeah, great question. Thank you. I almost have forgotten about it. So for other crypto assets, there are exemptions, of course. But since there are no requirements, again, there are no requirements for authorizations or licensing requirements, there are exemptions for preparing your white paper. So if you are soliciting less than 150 persons per member state of European Union, you are exempted. Or if your offering is less than 1 million euros in the previous 12 months, you're exempted. Or third exemption is if you are soliciting only qualified investors, you will be exempted from the requirements to prepare the white paper. For asset reference tokens and e-money tokens, there are exemptions for licensing requirements. So you don't need to obtain, for example, authorization if your offer is less than 5 million euros in the previous 12 months. And the second exemption is if you are soliciting qualified investors. For e-money token, the exemption is if your offer is less than 5 million euros in the previous 12 months, and if you are providing those services to the ground. So if there are holding, for example, you are exempted. And there are some other minor exemptions, but they are defined in the e-money directive. Okay, moving forward to the fourth step, white paper requirements. Every crypto asset category demands preparation of white paper. There are no approvals from home member states. Furthermore, for asset reference token and e-money token, you shall include a disclaimer that such white paper wasn't approved by home member state. However, every crypto asset issuer offer shall prepare such white paper. I repeat, For other crypto assets, it is the offerer who shall prepare the white paper. For asset reference token and emitted token, these are issuers who shall prepare white paper. And for other crypto assets, there are requirements. There are exemptions actually from not preparing such white paper. The fifth step is actually making the consistent with white paper marketing communications and publishing them on the website. There are no requirements for approval from a home member state. And the sixth step is very specific only to asset reference token and e-money token, since you shall keep at all time reserves with a value which must match tokens in circulation. So the proportion is 1:1. Furthermore, with e-money token, you shall also keep a proportion of 1:1, and actually 30% of funds received from your users, you shall deposit them into credit institution, with the right to invest all the other funds into low-risk assets. This is what my colleague Alex has told us about, that actually USDC is e-money token, notwithstanding the fact that it has some reserves in governmental bonds. So I propose moving forward. That is all for offerers and issuers, but we shall cover another big player here, the crypto asset service provider. So first of all, actually, the requirements regarding crypto asset service providers, they will be in effect a little bit later, so on the 30th of December 2024. But anyway, in France, for example, in France, such amendments has been already made. So now you can apply for CASP license. And actually, for those who already have the WASP license, they will be required to obtain the CASP license from the start. So WASP virtual asset service provider license, it does not automatically transfers to crypto asset service provider. So if you are not issuing crypto assets, if you are not offering them, if you are not seeking admission to trading with crypto assets, but you are dealing with crypto assets in other way, for example, you are intermediary, and for example, you provide custody for crypto assets, you provide exchange services for crypto assets, you provide some advisors on crypto assets, or the main criterion here, if you are dealing with crypto assets professionally, then most likely you are a CASP. After this step, you shall move to the second step. You shall be prepared for stringent compliance, and we will see it with the transfer of fund regulation on the forthcoming slide. Why they are stringent? Because actually it was taken from the already existing regulations like PSD2 and MiFID II. So PSD2, it actually Payment Service Directive 2, it actually governs payment service providers, and now those obligations were extrapolated on the CASPs, and for investment advisors, the same thing applies. The third step. So why it is important? Because actually, if we are taking payment service providers, they shall have legal entity in the European Union, they shall be authorized or licensed, and furthermore, they shall keep at all time the capital requirements to cover any possible liabilities, because they are dealing with the real monies. The same applies now to CASPs. So we move to the third step. It is when you shall decide in which country you will have a home member state. You will have a legal entity. So MiCA, actually, we will cover some questions regarding registered office, branches, and how it applies to everything. But MiCA, it requires registered office in an European Union member state for CASPs. After you have registered your legal entity, you shall move to the question of securing your licensing. So licenses can be obtained from the home member state authority. For example, in Germany, home member state authority will be BaFin. You shall apply to them with your application by providing some general information. as it is as usual, is such are information on your legal entity, on your shareholders. After that, some information on your procedures with anti-money laundering policies and etc. etc. However, there are also some specific requirements. So depending on your activities, you shall provide some information. For example, if you are providing custody services, you shall provide how policies describing how you work with funds which were delivered to you, and furthermore, how you segregate those funds of different users from each other. Furthermore, there shall be some general also, but specific for CASP's requirements, how you deal with any complaints, how you actually deal with anti-money laundering regulations, and which procedures you have implemented. So it is defined very clearly at MiCA, and actually there are even tables showing each specific requirement. Moving forward, the fifth step is actually securing your initial capital requirement. As I said, as with payment service providers, you shall cover your possible liabilities. And for CASPs, such starts at 50,000 euros. For example, if you are a crypto asset advisor, you shall have a minimum capital required from you at 50,000 euros. And it is actually up to 150,000 euros. And this requirements this is required from, for example, trading platforms. That is all for steps. There are, of course, additional requirements, as I said, for custody policies and how you segregate each funds and etc. But we shall move forward because every general, very important requirement has been covered. But now we will cover another vital, crucial amendment, which actually impacts crypto asset service providers, and these are amendments to transfer of funds regulation. So it is not a new regulation. It has been existing for a long time, but now with such amendments, this regulation covers crypto asset transactions, and crypto asset service providers as intermediaries and executives of those transactions, they now have some obligations. So first of all, there are 4 players now: originator of the transaction, originator's crypto asset service provider, beneficiary, and beneficiaries crypto asset service providers. So for originator's CASPs and for beneficiary CASPs, there are requirements regarding validation, verification of those transactions, and furthermore, record keeping. So now you shall ensure that all transfers include originator and beneficiary information, such as name, distributed ledger address, crypto asset account numbers, and so you shall verify the accuracy of the provided information. Furthermore, you shall remember that actually non-custodial transactions from one wallet from one non-custodial wallet to another is excluded from this regulation. So peer-to-peer transactions are excluded. But if the intermediary of CASP is involved, then they shall verify if the transaction starts from 1,000 euro that these self-hosted addresses, they really belong to those persons. So let's move forward regarding record keeping. So now the CASP shall keep all the records for 5 years, and if there are risks involved, then such term may be prolonged to even 10 years. You shall remember that these transfer of funds regulations will be in effect from 30th of December 2024. It will enter into force. Let's move forward. And these were some main obligations and requirements from CASPs. Moving forward, we will talk about regulators. So you shall remember that the most essential regulator for you is your home member state authority. As I said on the example, for example, if you are operating in Germany, your home member state authority will be BaFin. What they do actually? They actually authorize crypto asset services. They demand information and documents relevant to regulatory duties. They prohibit some crypto asset services upon confirmed violations. They publicize non-compliance by service providers, and they actually fine those who have violated the MiCA regulation or their applicable legislation. But home member state authorities are actually regulated by other regulators. Such includes European Securities and Market Authority, ESMA, and European Banking Authority, EBA. So as my colleague Alexei has said, ESMA actually it defines the direction of MiCA, and it has the power to issue the essential recommendations, which are actually obligatory for most of home member states to include them, and I'm sorry, 1 second. And actually to pay attention to them, because they define the classification and difference between those crypto assets. And the European Banking Authority, it is actually very crucial, since it can define the significant tokens. And most of all, it actually deals with banking sphere. So if you are a credit institution, if you are an e-money token, then you will deal with European Banking Authority. So let's move forward and speak about the last point here, about fines. So you should remember at each time that those discussions about licenses, about preparing all the policies, about submitting them to your home member state, they are not something just to be said. They shall be complied with, because there are severe fines. So for natural persons, since investment advisors sometimes may be other undertakings, including natural persons, the fines can reach up to 700,000 euros. Furthermore, for a legal entity, which is more relevant for us all, the fines may reach up to 5 million euros or 3% of their annual turnover. Furthermore, for some very severe violations, the fines may reach up to 15 million euros or up to 15% of the annual turnover. So the clearer fines will be drafted by the home member states authorities in the applicable regulations, but this is just a framework upon which those home member state authorities will be doing. So let's move forward to the conclusions. So the main conclusions you shall make from this webinar is that actually MiCA is more your friend. Of course, it is not an ideal framework, but what it does for sure, it actually provides us legal certainty regarding categories of crypto assets, regarding activities with crypto assets, regarding requirements which are imposed on those who deal with crypto assets. And furthermore, it provides clarity regarding which licenses you shall get, which authorizations you shall get, and provide us with an understanding who actually regulates all of that, and which fines may be imposed on us for any violations. So, thank you for attention. Let's move to the question and answer session.
Yeah, thank you for that. Actually, I want to emphasize as well that now with MiCA Enforce, actors can just get one license in one member state and do not require to get the license across the union. So it will be much more easier to operate in the European Union right now. Before we move forward to the Q&A session, I will ask about the...
Yes, sorry, Andrei, may I interrupt you? So I have promised that I touch upon branches and offices. So you shall remember that for other crypto assets, there is actually a requirement to have different actually presence in European Union. So now you may have a registered office, actually most of legal entity in the European Union. This is the first way. or branch if you are a third country company, or you can provide such. So you can provide even without, a registered office, branch, or without branch. But in this case, you actually may provide such other crypto assets to European country residents, but the home member state for you will be the company where you first has offered your crypto assets. However, contrast this with asset reference tokens and e-money tokens. Those requires from you to have legal entity in the European Union. And furthermore, as we have discussed it, for crypto asset service providers, you shall have a legal entity in the European Union as well. However, there is a possibility to provide some services to European Union residents for crypto asset service providers, but it is called under MiCA reverse solicitation. So only if the resident of European Union has addressed to your specific services intentionally by themselves, you can provide the services to them. But not like in general solicitation when you are targeting those European Union residents.
Okay, thank you for that. Yeah, so getting back to my question, so as a lot of people asked before the webinar, what is about the transitional period? So what's about the situation when the offerer finished his offer of crypto assets before the 30th of December? What will be the consequences for this offer? Is there any requirements to comply with? Can you please clarify that moment?
Yeah, for sure. So if you're talking about the transitional period, it is necessary to pay attention to the provisions of MiCA, which stipulate that certain articles which refer to the obligations of the issuers and offers of crypto assets other than asset reference tokens and e-money tokens. So those obligations for the white paper, marketing communication, etc., they will not apply. In case such crypto offering, they ended before the 30th December 2024. But in fact, it is necessary to understand that still, in case crypto assets other than asset reference tokens and e-money tokens that were admitted to trading before the 30th December 2024, they still may have certain obligations regarding the white paper and publication of the marketing communication. So that means that even in case you finished with your public offering before the 30th of December and you are free from requirements, that's okay. But in case your token will be or is already admitted to the trading on the trading platform, you may face with a certain requirements, for example, as for white paper and marketing communication. If we are talking about the crypto asset service providers, so MiCA provides a 2 years transitional period for them. In fact, for those who are currently dealing under the existing WASP regulations in certain member states of European Union, but also MiCA stipulates that member states, they may decide not to apply the transitional regime for crypto asset service providers provided for 2 years, by MiCA, or they may reduce the duration of such transitional regime and decide it by themselves, the applicable timing, and they shall communicate that, of course, also to the Commission and to the ESMA as a regulatory body. So in fact, it is necessary to pay attention to the rules regarding the transitional period for the crypto asset service providers in each member state, definitely in those which are you interested in or where you are now registered under the current WASP licenses.
Okay, thank you for that. Okay, so I suppose we can move to our Q&A session. Mr. Leon, you have a question, I suppose. You can write it down in the chat if you wish. Please, yeah. Okay. So first question from the chat is how MiCA intersect with the MiFID II. What can you say about that?
So I suppose that I can start. Maybe Vladislav will add something after that. In my opinion, and considering the provisions of MiCA, in fact, we cannot see some intersection between these two regulations because MiFID is a separate law, a separate act which regulates the financial market. But here, if we are talking about the MiCA regulation, it is necessary to understand and even to consider, let's say, the name of this act, markets in crypto assets in European Union, which means that by this act, in my opinion, regulators within the European Union, they are aimed to establish the separate market for the crypto assets, which will be regulated with a certain standards, provisions, and requirements for the actors who want to deal with crypto assets and provide the services within this market. Because in fact, as we discussed previously, in case your token, which may be classified as a crypto asset due to using of distributed ledger technology, blockchain, in fact, yeah, and will be stored electronically, but the nature of such asset still will be as a financial instrument or pension scheme or anything else. It will be regulated under the existing financial laws and regulations within the European Union. In conclusion, MiCA establishes direct rules and prescribes certain requirements to the offerers, issuers, and crypto asset service providers who are dealing exactly with the crypto assets according to the classification of MiCA. At the same time, MiFID, it regulates already existing financial market within the European Union, including discussed financial instruments, or transferable securities, and etc. And even if certain crypto assets will be classified as financial instrument, let's say, it will be regulated under the MiFID II.
Okay, thank you. I suppose that's it. Okay, let's move on to the next question about the difference between the issuer and offerer. For example, Circle Financial is the issuer of USDC, but who is the offerer? I suppose the answer is pretty obvious, but okay. Vlad, can you please answer that question?
Yeah, I can answer that question. Actually, we may address this question to the white paper of the Circle SAS, because it is a French company. So it was actually defined there, and it is included that the issuer is Circle SAS, and the offerer is also Circle SAS. Alexei, do you have anything to add here?
Maybe I can add. Yeah, to be clear in that, actually, offerer can be any platform. Let's say exchange which is leased USDC with. So, for example, Binance will be the offerer of the USDC if the USDC is listed on Binance for the European Union.
Yeah, I wanted to move here on example, actually, not the USDC. Actually, as we know, the Bitcoin is most like Daniel Larimer has defined it as a decentralized autonomous organization. In his case, it was corporation, but in Vitalik Buterin's case, a decentralized autonomous organization. So there is there are no obvious issuer of the token. So there are no issuer. There is nothing. There is nobody who can actually prepare that white paper and publish that. So in this case, as we were talking about other crypto assets, why actually most of obligations are falling on offers, because to cover these existing examples, like with Bitcoins. And actually under Article 68 of MiCA, for example, Binance can possibly be an offer. So actually, possibly they shall prepare the white paper of the Bitcoin to list it. You may find some white papers of Bitcoin. So there are some persons deliberately who created it. For example, on ResearchGate, it was published as a scientific work, like the white paper of Binance of Bitcoin. So anybody who is offering such crypto assets, they may use it. So if, for example, one trading platform has created the white paper as an offer for Bitcoin, other crypto platforms, the trading platforms, they may use such a white paper. So yeah, it is the most essential thing here. And yeah, as with USDC, the issuer may be Circle SAS. The offer may be also Circle SAS if it actually offers its crypto assets by themselves to public. For example, from the initial coin offering undertaken on their website. But actually, the offer also can be a trading platform.
Thank you for that. Okay, let's move forward. And the next question is about challenges that MiCA actors may face in future: money, timing, and unclear regulations. Maybe some words about that. I understand that the question is pretty broad, but maybe you have something to say. Olsi, please, maybe you.
So yeah, in fact, if we are talking about the challenges, of course, it depends on case-by-case basis, and especially on the type of services in general, on the type of activity that you are interested in and you want to provide. But if we are talking about the money, as Vladislav mentioned, it depends on the certain type of crypto asset services, for example, and requirements for the issuers and offers of certain type of crypto assets, because so there may be certain requirements for the capital contribution and amount of the capital of the company which shall provide the services and etc. That's the first point. Another one, of course, about the timing and probably about the maybe also money in question regarding the obtaining licensing, because I suppose that after the full implementation of MiCA, there will be rather a lot of requests, especially from those who deal under the existing VASP regimes. Of course, a lot of them will be interested in obtaining the current approvals, updated approvals under the MiCA regulation as soon as possible. That's why we may presume that there may be a lot of requests to the official authorities and regulatory bodies in different member states, and that's why such processes they may take some time. If we are talking about unclear regulations, here is a tricky question from several points of view. On the one side, we can say that, MiCA aimed to provide us with clear regulations, and we have like definitions for the crypto asset, their classification, and etc., etc. But as a lawyers, we can say that from the other hand, everything will be observed through the practice, and we need to obtain some practice to understand the approaches which will be taken by the regulators in different member states of the European Union, how they will see the classification, what will be the precedents, for example, or general approach for the classification of NFTs, especially those which are now trading in a lot series on the different marketplaces, also considering those which are fully decentralized. So that's why, of course, we will have certain unclear regulations, but only for the first time, because I'm sure that within maybe half a year and within the first year of the full applicability of MiCA regulation, we will be able to observe certain approaches, and we will be able to attest certain practice from the regulators, and it will make easier for us and for startups to navigate through this complex regulation.
Okay.
More, I would like to add here that, of course, as we have discussed before with Alexei, there may be problems with classification of those crypto assets, because as we have mentioned before, there is a problem with classification sometimes of stable coins, for example, of USDC as e-money token, and problems with classification of USDT. Of course, as Alexei said, it looks more like an e-money token, but if you will refer to some scientific researches, they state that it may be viewed also as an asset reference token, and it actually imposes different obligations. So before issuing any tokens, of course, you shall need to consult with your legal assistance beforehand. Actually, we deal with that. And furthermore, talking about classifications, of course, it is MiFID II regulation, which actually sometimes may intersect with MiCA, because the definition of financial instrument under MiFID is very broad. Briefly saying, it includes some characteristics as transferable asset, as negotiable, price negotiable, and which can be traded on the capital markets. So actually, sometimes it may include the crypto assets. And to delineate this, you shall also firstly consult with a legal expert on this. So yeah, I think that, in my opinion, the most crucial problem here is actually classification and delineating of different types of crypto assets between each other.
Okay, thank you. Thank you for that. And we have one more question about transition period as well. So if one applying this year but doesn't manage to receive a license before 2025, I suppose we're talking about the VASP license, what would be the applicable rules for an applicant? Do we need to apply again, or will the old rules apply to these applicants? Alexei, can you please?
Yeah, for sure. So as I mentioned previously, for crypto asset service providers that provided their services in accordance with applicable law before the 30th December 2024, they may continue to do so until the 1st July 2026, which means 1.5 years. And they may do so until this date, or until they are granted or refused an authorization pursuant to the MiCA regulation, which means that you may update your request to the regulators, even in case you do not obtain such approval before the full implementation of MiCA. But in case you will be totally, let's say, refused with the authorization, so as provided in MiCA regulation, it is not possible to provide the services even under the previous regime. But it is necessary, of course, also to pay attention to the local regulations and the transitional measures that will be implemented in certain member state. Because as you remember, we mentioned that member state countries, they may establish their own measures, and they may change the transitional period, for example, for 1 year, half year, or even immediately.
Yeah, thank you for that. Exactly. So if you already applied, for sure you'll be need to update your application to be adapted to meet the MiCA requirements, for sure. and to be sure that you understand what the home member state authority wants from you, because the approaches may differ across the union in this question. Okay, so about the next question. Next question is actually was asked before the webinar. It's about the technical measures that may be introduced in MiCA. So actually, does the MiCA introduce any technical measures that should be adopted by the crypto asset service provider or not, or maybe where we can find any technical measures to be adopted for the crypto asset service provider? Who may ask about the answer?
So we can say that in general, MiCA provides the requirements, as we can see, not to the technical part, but MiCA describes the provisions and general approach regarding the regulations and requirements from the legal point of view, and considering the rights and obligations of the participants of this market. In fact, as for crypto asset service providers, as for offers, issuers, and those who are seeking admission to trading. That's why we can say that if we are talking about some technical requirements, they are not covered by MiCA regulation. And there are no certain prescriptions that you shall have like certain software or something like that to be in compliance with MiCA and etc. MiCA doesn't contain such information.
Okay, yeah.
Furthermore, for Digital Operational Resilience Act, which will be in effect in 2025, so it also actually imposes most of obligations on financial institutions. So they shall ensure that all the operators, the white paper solutions, or some software developers, they are providing their services diligently and not introduce any bugs intentionally there. Mm-hmm. So actually, under some of court practices in many jurisdictions, actually, there is a possibility to pierce the veil and to impose sanctions on the services provider, who actually may be an IT company who developed some code, if it has intentionally introduced the bugs in the code.
Okay. Yeah, thank you for that, because we actually get to that question from the white label service providers. So yeah, I suppose now they understand that the law they should deal with will be DORA Act, not MiCA directly. Okay. So about any other questions? I suppose we're done. There is no other questions.
So I can see one more question in our chat. How stable is regulation considering the evolving nature of the crypto industry, and what avenues exist for lobbying, and what industry bodies are leading this? Here we can say, I suppose, only our personal opinion, because it's like only the thoughts and views different actors, including us as lawyers. I can say that, in my opinion, of course, MiCA is not the excellent and is not the act which will cover all the issues and definitely will regulate all the relations with the crypto assets, because we can see even the situation with the DeFi sector, yeah. But at the same time, MiCA definitely provides some clarity, especially as for regulation of the crypto market and financial market. Yeah, we still don't have practice, and we will wait for that regarding, as Vladislav mentioned, classification and what approaches will be in different member states. But still, it is, in my personal opinion, better then go to the US market, for example, while you're every time think, will SEC consider our token as a security or not? Shall I enter these markets, or it's still dangerous, and etc. etc. Because they only provide like Hobby test and say that okay, we will consider the Hobby test and that's all. And you may not know the moment when they will be interested with your project. Here with the MiCA, we have a little bit more clarity because we know that we shall submit the documents like white paper and etc. But at the same time, we have even preliminary like clarifications from the ESMA, which is regulatory body, and regarding exactly the question about the bodies leading these. So it will be like on the regulator's behalf, of course, it will be ESMA as a regulatory body and EBA in the European Union. As for players in the European Union, we can see only at the moment that they will discuss the situation with the key players on this market, and they will get their response to navigate through this regulation, and to navigate through this process, because in fact the regulator, they are also interested in development of these markets, and I suppose the MiCA is the first step towards that.
Yeah, first of all, I would like to answer that eventually we have a legal certainty regarding crypto assets regulations, and as Alexei has said, finally we have eliminated the discretion, that much discretion as the Security and Exchange Commission in the US have. So now we have the understandable framework within which we will be working. Furthermore, actually, European Union has introduced not only the framework like MiCA, it also has introduced some regime where you may work and understand if you are violating anything. So it is called distributed ledger technology pilot regime, and it is like a sandbox in many European Union countries. You may work there under the surveillance of your home member state, and they will tell you if you are violating anything or something like that. There are no such fines for that. There are no actually, there is no requirement ordinarily to obtain any licenses to work in this regime. It's just a test regime to test your products and with an observation of the home member state authority.
Okay, thank you.
Yeah. So I can add a comment to the one more statement which I can see in our chat from Ryan, which is equivalency is important, for example, with UK, USA, and etc. Yes, for sure. And in fact, we can see some general approaches which are taken by the USA, still by the SEC, Securities Exchange Commission, and even MiCA regulation, because in the question, for example, of the classification crypto assets which can be considered as transferable securities and as financial instruments in general, regulators in the European Union, they still follow the approach substance over form, and same risks, same activity. That's why same regulations. And if we're talking about the approach in the United States, we can pay attention to the case SEC versus the DAO. I suppose you have heard about that. And there they stated also regarding the classification, they also stated that it is necessary to pay attention to the substance over form approach and to consider the nature of certain assets. But still, in fact, except these statements in their court cases, SEC cannot provide more information about the key points which they pay attention to. At the same time, in my opinion, we have more let's say, more clear situation with the ESMA and with their guidelines, clarifications, because they try to navigate through these questions. Yeah, of course, we understand, as Vladislav mentioned, that transferable securities and in general financial instruments is a rather vast definition which is used in the MiFID. Yeah, but they provide like certain markers and certain key points which we can consider to understand better whether we shall be regulated under the financial instruments law or under the MiCA regulation.
Okay, thank you for that. Okay, as I see, there is no more questions, and I suppose we can finish for today. I hence everybody to share your feedback about our webinar in social media, especially in LinkedIn, if you use it. We really appreciate that. And if anybody wants to discuss their projects, their business in and how the MiCA and other new regulation will impact that, we're happy to do that personally, maybe next week if you wish. So yeah, please stay with us and share your contacts, and we will commute you regarding the personal meeting. Yeah. So thank you everybody for today. Really, it was really good webinar about the these regulations. So I suppose you enjoy, and we'll be happy to cooperate in future. Thank you for that.
Thank
See
you
you.
very much. Have a nice day.
Thank
everyone.
you. Have a nice day. Bye.
Bye, everybody.